now to conflict of interest. Allegations of, questions about alleged conflict on the part of the Attorney General were asked. The laws and the rules on conflict are very clear. These rules on conflict will be observed. The Attorney General and Deputy Attorney General Hari Kumar will not be involved where there is any conflict. They have abided by the rules of conflict, and there is no basis to suggest that either the Attorney General or the Deputy Attorney General have not observed these rules. An example of how the rules work would be when lawyers move from the AGC to the bench and vice versa. So take, for example, former DAG Tan Seong Tai, who was from the AGC. He recuses himself from any AGC-related matters now that he has returned to the bench. Likewise, the Chief Justice in relation to any matters he handled when he was at the AGC. Similar rules apply in private practice as well. If a lawyer moves to a new firm, he observes the rules on conflict. He doesn't involve himself in his new firm on matters which his old firm had acted. This has been debated before in relation to the appointment of the Attorney General and the Deputy Attorney General. Mr. Lucien Wong, we've already referred to his credentials previously. He was the senior partner of the largest law firm in Singapore. He is widely acknowledged as a top legal mind, consistently recognized as one of Singapore's best, and his appointment was welcomed by the bar. The Law Society has called him a formidable and creative legal mind with proven management skills, a practical track record, and a skill set uniquely equipped to deal with the evolution of the changing legal environment in Singapore. As a lawyer of almost 40 years standing, Mr. Wong would have had thousands of clients. There is no reason why this should be an excuse for us to pass him over and choose a less qualified candidate. Similarly, Mr. Hari Kumar is amongst one of the top 6 to 7 litigators in Singapore today. If you look at the people from within the service who have been appointed to key positions, the DAG and the SG as well, these are young, some of them in their 40s, and we hope that in the future, from among their ranks, someone can become Attorney General. Mr. Wong's appointment as Attorney General was decided after a thorough and rigorous process. The Prime Minister consulted the Chief Justice and the Chairman of the Public Service Commission and the incumbent Attorney General on the appointment. The CPA unanimously advised that the President concur with the appointment. The Council of Presidential Advisers, that is, unanimously advised that the President concur with the appointment, and the President, acting in his discretion, also supported it. It is also not unusual for the Attorney General to be known to the Ministers or the Prime Minister. You will recall that our first Law Minister was very successful, being one of the, you'll recall that the Law Minister, Mr. Eli Barker, was very successful, and one of our founding fathers was an old friend of Mr. Lee Kuan Yew and a partner in Lee and Lee. This did not prevent him from being a good law minister. With respect to past judicial appointments, these have included lawyers who acted for Mr. Lee Kuan Yew, such as Mr. Joseph Grimberg, or who worked in Lee and Lee, for example, Justice Lai Kew Chai and Mr. Andrew Ang, who's currently on the bench. All were or are well-respected members of the bench. Former Chief Justice Yong Pang Hao was an old friend of Mr. Lee's from Cambridge. He is credited with modernizing the Singapore judiciary during his time on the bench. In these roles, all of them observed the appropriate conflict rules. Ultimately, the most important considerations are the quality, character, and integrity of the individuals involved, and that is the hallmark of our system. And indeed, in many first world countries, the AG is even a sitting member of parliament or a politician. In the UK, the Attorney General is a cabinet minister, likewise, similarly in Australia. Our system is based on a slightly different model, but as we've said before, it goes too far to suggest that AGC officers must not have previously had any links with any ministers or political party.
The first point is that she told the House that the AG and the Deputy AG have been observing the conflict rules in their functions. I'd like to ask her categorically whether she's saying that the AG and the Deputy AG, Mr. Kumar, are not involved in advising the government on the matters concerning the Lee estate. That's the first clarification. The second clarification is she mentioned the fact that there have been friends of ministers who have been appointed to various organs of state, and I think she mentioned the judiciary as one of them. But does she not agree really that for the AGC, what we're faced now with is not the judiciary where there's security of tenure, where judges are appointed secure till 65, but we have an AG now who is on a short-term contract, 3 years. That puts a very different complexion on things. Third clarification is, does she agree or not agree that it is desirable to have distance between the AGC leadership and the government, which was what was believed by some former ministers, including Professor Jayakumar, or have standards changed?
The second point, Ms. Sylvia Lim said it is different from the bench where there is security of tenure, but in AGC there is no security of tenure, which puts a different complexion on things. It does not put a different complexion on things. All lawyers, good lawyers, understand their duty, which is simply this: if you're in a position of conflict, you do not act, you recuse yourself. And as to whether it is desirable to have distance, the correct question really is, are the members or are the officers of AGC, do they act independently? In other words, if there is a conflict, do they stand aside? Do they apply their minds to this without fear or favor? Do they do their duty? And the answer to those questions is yes. They do act independently, they apply their minds, and they carry out their duties without fear or favor. So in short, the officers in the AGC, whether it's the Attorney General, the Deputy Attorney General, or anyone down along the line, all observe proper rules of conduct.
And the second clarification is, she didn't answer directly. She said I asked the wrong question about whether there should be distance between the AGC and the government, because the critical question to her was whether the officers act professionally and independently. But this is really quite a different take from even Professor Jayakumar, because if you read what his interview goes into, he says that he may occasionally have lunch, working lunches with the AG, but it is important to have the appearance of distance. You cannot get too close to these people because people might assume that there will be some compromise. So I think it is the appearance itself is also important, not just in fact whether people think they're able to act independently, but the appearance of when you're too close to somebody, it doesn't create a good feeling.
With respect to the other matters, I've already explained. There have been instances before when either the Attorney General or judges may have been close friends with ministers or anyone else, but that has not deterred them from doing their duty. I understand what Ms. Lim is saying. She's saying actual conflict and sort of appearances. In terms of any actual conflict, I've already stated the position quite clearly. They know their duty and they will carry out their duty. They will not act where there is any conflict of interest. And as far as appearances goes, if she has any specific allegation of that, please highlight it, because as far as I can see, there has been no form of impropriety, appearance or otherwise.
May I remind members that we are not debating on the role of the AGC or the Deputy AGC, so please confine your clarifications to matters which SMS Indranee Rajah has said. Mr. Ratiakan.
Thank you, Deputy Speaker. First of all, the SMS seems to suggest that I say there's no evidence. Is what we say. I say scattered evidence about what they presented. Right. Secondly, on the question of conflict of interest, it seems to me it says that so long as there's a conflict and you stand aside. But the question then is, how would the member of public or anyone else, whether in such a particular case, I mean, the AG stand aside or is he not stand aside? Thereby, my question is, important appointment like such, or Minister for Law, or even senior judges or whatever, is it that the public perception of its independence and impartiality is important? Is it not important or is it important? Secondly, if there is a question of doubt, then what should the government do?
On appointment, as I said earlier, when the Attorney General was appointed, the Prime Minister consulted the Chief Justice, he consulted the Chairman of the Public Service Commission, as well as the incumbent Attorney General on the appointment. Due process was observed, and there is absolutely nothing wrong with the current appointment of the Attorney General. On conflicts of interest, I have already answered that. It is not necessary for me to repeat it again. Indeed, it is only Mr. Loh and Ms. Sylvia Lim who keep raising this issue. There is no basis for any concern that the Attorney General has not acted in a manner that is entirely proper.